Board of Directors. Section 2(34) of the Companies Act, 2013 prescribed that director means a director appointed to the board of a company. Section 2(10) of the Companies Act, 2013 defined that board of directors, or board, in relation to a company, means the collective body of the directors of the company. Minimum and maximum number of directors. Section 149(1) of the Companies Act, 2013 requires that every company shall have a minimum number of 3 directors in the case of a public company, 2 directors in the case of a private company, and 1 director in the case of a one-person company. A company can appoint maximum 15 directors. A company may appoint more than 15 directors after passing a special resolution in general meeting and approval of central government is not required. Maximum number of directorships, including any alternate directorship a person can hold, is 20. The number of directorships in public companies, private companies that are either holding or subsidiary company of a public company shall be limited to 10. Further, the members of a company may restrict above-mentioned limit by passing a special resolution. Residential status of a director in India. Every company shall have at least 1 director who has stayed in India for a total period of not less than 182 days in the previous calendar year. Disqualifications for appointment of director. Section 164. SEC 164, 1. Disqualification of individuals. A person is disqualified to act as a director if he is of unsound mind and stands so declared by a competent court. He is an undischarged insolvent. He has applied to be adjudicate as an insolvent and his application is pending. Are convicted of offences. Imprisoned for at least 6 months. An order disqualifying him for appointment as a director has been passed by a court or tribunal and the order is in force. Non-payment of share calls. SEC 164, 2. No person who is or has been a director of a company which has not filed financial statements or annual returns for any continuous period of 3 financial years, or has failed to repay the deposits accepted by it or pay interest thereon or to redeem any debenture on the due date or pay interest due thereon or pay any dividend declared and such failure to pay or redeem continues for 1 year or more, shall be eligible to be reappointed as a director of that company or appointed in other company for a period of 5 years from the date on which the said company fails to do so. Provided that where a person is appointed as a director of a company which is in default of clause A, or clause B, he shall not incur the disqualification for a period of 6 months from the date of his appointment. Disclaimer. This video is intended solely for educational purposes. The information provided is based on current understanding and should not be considered professional advice. Please consult with a qualified professional for specific guidance related to your situation.